Legal Times, and National Law Journal. She has been ranked by Chambers and Partners USA, the preeminent attorney research and ranking company since 2009. For 30 years, Connie has represented employers, boards, and individual executives, partners, and owners in employment-related matters, including employment contract, discrimination, whistleblower, trade secret, and employee mobility matters. She frequently conducts confidential internal investigations concerning employment matters, including alleged fraud, theft or misuse of company data, discrimination, harassment, and code of conduct violations. Sorry about that. My script just went away. Give me one moment. Sorry about that. Sorry about that, everybody. Just had a little bit of technical difficulties where my Word program shut down. So let me get back to that introduction. Including also is Andrew Sakalaris. He's a senior corporate counsel for LMI Consulting, which provides management consulting to the federal government. Prior to joining LMI, he was an attorney at Morgan, Lewis & Bockius LLP in Washington, D.C., where he specialized in employment law, class action defense, and employee benefits litigation. He also serves on the ACC National Capital Region's Board of Directors and the co-chair of its Employment and Labor Forum. Amanda Dupree is Associate General Counsel for E+ Incorporated, a leading consultative technology solutions provider. Prior to joining E+, Amanda practiced labor and employment law as an attorney in the Washington, D.C. office of Morgan Lewis. She's also co-chair for the ACC National Capital Region Small Law Department Committee. And Virginia Robinson is Deputy General Counsel at DynCorp International, an American company. In that role, she serves as a lead labor and employment counsel for the company and handles a wide array of investigations and litigation. She has over 15 years of experience with employment and business litigation and co-chairs the ACC NCR Litigation Committee. So thank you for joining us today and leading us in this discussion. Connie, I'll hand it over to you now.
Thank you, Ahmed, and thank you for the kind introduction and then your support with the program. Today, we wanted to kind of dig deep in issues relating to investigations of whistleblowers. Recently, we have had what I'd characterize as a perfect storm for whistleblower claims. You have employees who are highly educated about whistleblowers and whistleblower claims, and they know how to use their voices after a tumultuous year. And after COVID, employees are feeling disenfranchised and operating in an atmosphere of fear. They've either been working in their homes remotely without as much contact as usual, or they've been in the trenches working with the fear of contracting COVID. And we have a situation where, because employers have been cutting jobs recently, there's the usual uptick in litigation and claims that follows that. And as of right now, the #1 claim being filed is for whistleblower and retaliation claims. Today, we're going to be focusing on some of the more challenging issues related to internal investigations. And we have 6 segments. First, we're going to talk about best practices, or maybe what we'll call worst practices. Second, we'll talk about the retention of independent counsel. Third, we will discuss the preservation of the attorney-client privilege, which is a very challenging topic in internal investigations. Fourth, the obligation to report up to the board, and then things can go knock in the middle of the night with the board concerning an investigation. And fifth, restricting communications of complainants and witnesses and self-help discovery. And then finally, a very practical discussion of the things that in-house counsel can do to reduce the risk of whistleblower and retaliation claims. Now, let me first turn it over to Virginia, who's going to be talking about conducting effective investigations.
Great, thank you so much, Connie. It's a pleasure to be here today with you and the other panelists. Kasha, if we could move forward, I think a couple slides to, great. So that's the intro, and now we're talking about, conducting effective investigations. So, you know, one of the most important things I think about doing any kind of internal investigation is having a really thoughtful and fully formed plan before you even begin. And I'm going to talk about that a little bit, but To me, the most important step actually comes before you ever even receive a complaint. And that is proper training and relationship building with your HR and your business leaders to make sure that when a complaint comes in, that may be something that is particularly concerning, something where we really need to make sure that it's addressed correctly, that they know to reach out to you before they just start conducting their own investigation. So it's really, really important in your role as in-house counsel to stress to your HR team, your business leads, what are the types of situations where you want them to put everything down and call you before they start taking any action? Because you know, you can otherwise kind of get something that comes to you where work has already been done and it might not have been done thoughtfully. It might not have been done under privilege in a case where you want something conducted under privilege. There are a lot of issues with that. So, you know, what I usually do is I usually frame it as anything that's potentially illegal activity. If there's an allegation of you know, sexual harassment, if there's an allegation of fraud, if there's an allegation of any kind of illegal activity, I want to hear about it before anything happens. I don't want any emails sent. I don't want any documents gathered. I want to know right away. If management feels like they need to brief their own management chain, I tell them that's fine, but I want to be on the phone for that call, you know, so that we can try to make sure that if there's any issue where we need to try to maintain privilege, we do that from the very beginning. So before we even get to that whole stage where we're thinking about how to plan our investigation, we're laying the groundwork with our business partners about how to make sure that anytime something concerning comes in the door, you get to be part of planning that investigation and make sure that it's being done in a thoughtful way. So that said, you know, the first thing that I do when an issue comes in is I want to look at it and I want to make sure that no immediate action needs to be taken. You know, depending on the allegations in a complaint, you may need to try to separate employees, make sure that they are working at different sites or at different times from each other. You may need to suspend an employee pending an investigation. You know, for instance, what if there's an allegation that's credible that an employee is using illegal drugs and there's somebody that works on heavy machinery? You know, there are a lot of reasons that you might need to take some sort of immediate action. So I think the first thing that I do is I try to just look and see, is there anything I'd have to do right away? Is there anything I need to ask HR or our business partners to do right away in this circumstance? Is there a concern where we need to just immediately lock down any kind of documents or evidence, you know, where the steps need to be taken before anything else occurs? Then the next thing that I want to do is I want to understand exactly what the allegations are. You know, it is not unheard of. I know probably a lot of people on this call have gotten the 20-page single-spaced you know, complaints or emails or concerns where you really have to set aside half an hour where you're not going to answer emails or calls and you've got your highlighter out and you are going through really just trying to distill exactly what are the issues that need to be investigated and what are the things that don't, so that you completely understand from the beginning what you need to look for. And then I think it's important to think about what are some of the issues that might stem from what's alleged in a complaint. You know, what are some of the issues that, while they're not, you know, necessarily listed here, might come out. And so I think, you know, you really need to understand exactly what is in the complaint. I also think it's incredibly important, and we'll talk about this a little bit later in the presentation, but one of the most important things you can do is make sure that you're acknowledging receipt of the complaint, right? That you are in some way letting the reporter who has brought this concern forward know that it is going to be looked at. And we can talk in a little while about who should deliver that information, you know, and what information should be shared throughout the investigation. But I think an initial response is really important. And if you have a third-party hotline system, it can be as simple as simply making sure that there's somebody who sends an immediate response through the hotline, you know, that just says something like, thank you for, you know, raising your concerns. You know, we will take a look at this and someone will be back with you shortly. But just some sort of initial recognition that, you know, that this is not just falling on deaf ears or disappearing into a black hole, because what you don't want is for a complainant to suddenly start engaging in self-help early when you have a chance to get involved in the investigation. The next thing that's important is figuring out who's going to manage the investigation, who's going to conduct the investigation, who's going to support the investigation, and who needs to know the outcome in the investigation. And those things can all be the same people, they can all be different depending on the concerns that are raised. So, generally speaking, the investigation is going to be managed probably by some combination of, ethics and compliance professionals, HR, internal audit, legal, or other, professional support, depending on what the allegations are in the complaint. I think it's generally good to make sure that you've got somebody managing the investigation that's got sufficient knowledge of all of the different pieces that might arise. Complaints can be manifold, and have lots of different components. So you may want somebody who is a compliance investigator to oversee something that's going to need support from multiple departments. But you do want somebody to be responsible for managing the investigation from the beginning to the end and putting together that investigative plan, and reassessing that plan frequently throughout the course of the investigation to make sure that the plan that you originally conceive of in your head is still appropriate as new things develop throughout the course of the investigation. And then you need to think about who can conduct this investigation, who can support this investigation. It might not just be one person, it might be multiple people. I think the most important thing is to make sure that the people conducting the investigation have sufficient independence from anybody who is alleged to be potentially a bad actor in the complaint. So for instance, if you have a remote location and you have an HR person at that location and they're excellent, but the allegations are against, the manager of that location, that HR person might feel like it's very difficult for them to support that investigation. So you need to think about how can you pair resources to make sure that people with sufficient independence are actually the ones conducting the investigation. You may need to rely on support from people with technical expertise. It would not be uncommon to bring in somebody from internal audit, somebody from environmental health and safety, to help you understand the technical points of a complaint and maybe even assist with the investigation. And then I think you need to think about ultimately who needs to have information about the outcome of this case and who does not. A good example is that obviously in the employment law context, it can be very good for a manager of somebody who has been reporting a complaint to have no knowledge whatsoever of the protected activity, if they don't need to in order to accomplish a comprehensive investigation, because that's going to be a defense for you to any retaliation claim down the road if a decision maker does not have knowledge of the protected activity. So you want to think about, who is going to need to participate in the investigation, but who can we potentially protect from that information if it makes sense, and we can still conduct a fruitful investigation. The next thing I like to do is really think through what are the documents that I might need down the road in order to understand this investigation. And a lot of the time, the documents are a roadmap to who you need to talk to, but it can also be great to have already reviewed documents before you start conducting your interviews, because there's going to be questions that are going to come out of some of the things you're going to review. And it gives you a roadmap to having those interviews. So I like to kind of think out all the way in my head, just a quick, kind of overview of who do I need support from, who's going to run this, who's going to assist with it, what documents do we need to look at, and then who are we going to interview? And not just who are we going to interview, but in what order, because obviously, some interviews may only be necessary depending on the outcome of the initial interviews. And again, you want to make sure that you're protecting the integrity of the investigation and being very thoughtful about who might share improperly, but still who might do it. The fact that they've been contacted about an investigation or interviewed with other potential witnesses in a way that might affect the quality of the information that you're going to get out of interviews. And then I like to think about the timeline. Like, is this something that we need to, try to get on very quickly? Can it wait a day or two? You know what I mean? What are the time factors here? for the investigation. And then one of the most critical decisions is going to be, do I want a written report? And there are a lot of reasons I might, and there are a lot of reasons I might not. And we're going to talk a little bit about that in the context of the privilege issues, later in the presentation. But I think there is an instinct to always document everything with a report, and that might not always be the best outcome. There are some circumstances where I think you do need a report. A great example is in the employment context. If you have a discrimination, a harassment claim, the fact that you investigated promptly and took any appropriate action where there's an allegation of a peer-to-peer harassment can actually be a defense to any claim that's filed in the future. And so in that case, you probably do want a report that documents what you did and how you did it and what steps were taken and what you looked at, and shows how comprehensive your reaction was. In other circumstances, you might just be creating a potentially unprivileged document that could be unhelpful to you. So I think you just need to think about, in each case, what's the benefit of doing a written report and what are the detractions, and try to make a decision at the beginning whether or not that's something you want to do. Understanding, of course, that throughout you're going to need to reassess, what is my initial plan something that makes sense. And then as you do your interviews, you want to think about whether or not you need a confidentiality instruction, for the witness in order to preserve the integrity of the investigation, and whether or not, you want to try to assert privilege over that discussion. And again, we'll talk about that in a little while. So those are kind of all of the things that I try to make sure I have some idea of what I want to do at the beginning of an investigation, before I even get started. Connie, is there anything that you would like to add to that about, what you advise your clients to do when they're planning their investigation?
I think you hit on some really good points, Virginia, and provided a really good overview of the various issues, particularly the importance of planning. Another point to make is, as you're going through this process from the planning to the execution to the final result, is to look at the investigation through a litigation lens. And you made a great point about the reports. You may need a report, or you'd be more persuasive if you present a completed report in connection with an investigation. But in a more complicated, nuanced situation, it may not be appropriate or necessary to do a report. But if you're going to do a report, you want to make certain it's a report that could be presented to a judge and to the jury and to witnesses, that's going to be, truthful and complete and compelling if there's a result that's in your favor. And sometimes these are hastily written. Some of the reports I've seen written, I would never ever put in front of a jury. And that, that's a big part of your role as in-house counsel, is to make certain that the record is made, that it's accurate, and that it's complete. Now, at this point, I thought it'd be good, we want to be practical in the presentation. And at this point, I was going to ask each of our in-house panelists about kind of the worst error that they've seen in certain areas. And I'll start with you, Andrew, in the big purple spaceship. What's the biggest error that you've seen in counseling clients, either in-house or when you were at a firm, in conducting interviews?
So I think one of the biggest errors that I've seen, and this is more prevalent, I think, when you have non-attorneys doing the interviews, is that when you have somebody in HR audit that doesn't really understand what their role is here, and then they make statements that are ultimately unhelpful, or they reach sort of impromptu conclusions during the interview. For example, if you've got an HR person who, let's be honest, is more inclined to be sympathetic than frankly most lawyers are, basically expressing sympathy with the cause of the person who's raising the complaint, even if that sympathy is warranted, that ultimately can lead to giving certain impressions down the line that, maybe would give the impression to the complaining party that they were in fact correct in their complaint, when, at the end of the day, the ultimate conclusion of the investigation is that they were not. I mean, this is especially true when you're talking about things like sexual harassment, where there's a sexual harassment itself is sort of a legal term that has a legal definition. And it's not as broad as in any form of harassment sort of qualifies. It's not as broad as what we would consider appropriate workplace conduct. And there's a line between what's inappropriate and what's legally actionable. And I don't think necessarily that most non-lawyers quite understand what that line is. And so that's where I've seen, investigations really trip up, and especially when you're using non-lawyers.
And Virginia, turning it back to you, what's the, with respect to communicating with the complainant, what errors have you seen?
Well, I think that the biggest error is not doing it, right? Or not doing it frequently enough, or, making them feel like no one is taking their complaint seriously. So I think, communication early and often with the reporter is important. I like to, for instance, if there's an online hotline, third-party hotline system that a client, uses, I like to ask them to check it daily and see, is the reporter checking the case? Are they looking actively at what is being done? When was the last time somebody spoke with the reporter? And just kind of, you don't have to provide necessarily information about it, but you can just let them know that the investigation is still actively being worked. It's amazing to me how just feeling heard can really be important to people regardless of the outcome of the investigation. And so I think, that just communicating generally with the accused, with the complainant, the failure to do that is really problematic. And I think the same thing is true with the subject of the investigation.
Right.
If you have somebody who is like a manager and suddenly they become aware that a complaint has been made against them that's very serious, a lot of the time you're going to see people freak out, and they're going to start engaging in behaviors that are not helpful to the company, and that can be true if the subject is completely innocent of any kind of misconduct, right? But it's a natural reaction to feeling like your livelihood is on the line, especially depending on the nature of the allegations against a subject. And so I think trying to be, transparent with the subject and communicate with them about the status of things as well, so they're not just sitting there knowing that they were interviewed about potential misconduct, and then 2 weeks has gone by and they've heard nothing. Are they going to start turning into trying to create a protection for themselves by trying to generate some kind of issue, in order to stave off any termination? I do think it's important to communicate with the subject as well as the reporter.
And Amanda, why don't you talk about the area where you've seen errors in connection with creating a record of the investigation and the results of the investigation, and then you can transition us into the next topic, which is the retention of independent counsel.
Sure, thanks, Connie. Building off of Virginia's excellent outline of effective investigations and what to think about, really taking a gestalt view, a real step back and thinking about from even beginning the investigation, issues like preservation and spoliation, making sure that you're documenting, that you're taking the steps necessary as you're pulling those relevant documents to ensure that they don't go anywhere. Because you might find yourself arguing a sideshow issue of, when did I issue my litigation hold, and was it sufficient, and did the recipient understand it? Because on the merits, you're going to win. So thinking about, even before beginning the record of the investigation, how you're going to show your work that you have taken the steps necessary to ensure that your investigation is going to be well supported and that you're meeting your ethical obligations as to the court. Also thinking about the end result. Do you want a report? As Virginia mentioned earlier, maybe you don't. Maybe you want a memo, maybe you want bullets. It really depends on who your audience is going to be. Will it be the board, C-suite executives? Will it be middle management? Is it going to be made public? And I like to think about, and I think all the in-house community will think about what kind of experience we want for our company. Investigations are scary, especially to people who don't conduct them every day. And so do you want someone who is going to come in and build your record on a flashbang, shock and awe sort of way, or do you want someone with a more delicate approach? And of course, that's going to depend on the nature of the claim and the people that are involved. And of course, privilege and managing privilege throughout the process as appropriate is critically important. And we've got a section on that, so I won't belabor it here.
Well,
Connie
and if I can add, Amanda, the other thing goes back to Andrew's comment earlier, which is, I think it's really important to train compliance investigators and HR, team members about not using words that mean one thing, in a legal context and another thing on the street. So, we always talk about, my favorite word is the word harassment, right? Because, and hostile work environment, like if I had $1 in my 15 years of experience for every, I am being subjected to a hostile work environment, when really they just mean my boss is a jerk, right? And so, training the people that might be writing a report out of using imprecise language like that is really important if you're going to create a report. And so, I always talk about, just using incredibly factual, descriptive language, not using like adjectives and summaries and conclusions, but rather just this is what occurred. And I think it's just really important to stay away from those legal buzzwords if you are going to document, investigative results.
I think that's a great point. One of the instructions that I usually give to my HR investigators is I don't want a conclusion in the report, just the facts, ma'am. You can give me a recommendation offline based on your prior experiences with similar claims or occurrences of the company, but I don't need a recommendation in the document, especially if my conclusion is different and I make a different recommendation. I don't want a document to undercut that.
Yeah, I think to sort of further that point, sometimes even a conclusion isn't really a conclusion, right? A lot of times what you come up with in an investigation is that there really is no conclusion, especially when you're talking about people who feel like they were mistreated or treated unfairly in terms of their performance. We as lawyers don't have a great way to gauge the performance of a lot of the people that work for our company because, one, there may not even be an answer, right? Most jobs don't have that objective of a standard that one can apply. And a lot of it comes down to sort of the discretion of the management. And so, I prefer that, when HR is looking into things that they talk about, the evidence doesn't support the retaliation claim or something like that, rather than saying, this person shouldn't have been fired because, they were in fact meeting the standard, sort of take the opinion out of it, focus on what the evidence shows rather than what this person ultimately thinks happened. And I think that's how you sort of avoid getting yourself in trouble.
Mm-hmm.
Now, we talked about the selection of the investigator, and Amanda, why don't you take the next slide addressing the use of independent counsel, which at least according to the media, everyone's using independent counsel these days.
Yes, everybody's doing it. So threshold question, do you really need independent counsel? It depends on your problem, right? Do you have a $10,000 problem or a $10 million problem? Is it likely to recur? Is it temporal? Is it fleeting? Has it been fixed already? Determine what kind of problem you have, the kind of counsel you need, and of course, staff accordingly. So if it involves your CEO or your CFO or your COO, yes, probably you're going to want independent counsel. You're going to want to choose that counsel very carefully. For someone who's in a mid-level management position, that might be more firepower than you need to bring to the problem. You may have the bandwidth to handle it in-house, depending on the size of your department or the expertise of the people who are available to support your investigation. You may choose to use existing outside counsel who are already known to your company and who can hit the ground running and may even know some of the players. I think more likely you would use independent counsel when litigation or investigations are likely to occur, if you're likely to be sued and it's going to be public, or you're likely to be investigated in a regulatory action, or if it's going to hit the press. You might want to be able to fall back on having relied on independent counsel to conduct a full and thorough investigation. If you are a publicly traded company and damaging allegations in the press is going to move your stock price, you want to make sure that you've really buttoned up that investigation so that you can rely on it. And of course, companies that rely on public trust for their, in industries where reputation matters and they need to avoid even the appearance of a conflict, that would be a great situation where you might want to bring in independent counsel. But once you get them, once you bring in independent counsel, right, it's not over. That's where the fun began. And we've delicately called it challenges of independent counsel, which I think is a very nice way of saying it. So if you're using truly independent counsel, you may know the firm, but not the person in it. And in some situations, the firm may be unknown to you. I know if given my druthers, I tend to use known quantities, not necessarily the firms that you read about in, the New York Times or the Wall Street Journal or the Washington Post, but firms that I know have excellent lawyers and can produce the result that we need for the company. So you might find yourself in a situation where, for example, you land with a firm that has an excellent white collar criminal practice and they are fantastic at performing investigations, but they are wholly unfamiliar with the nuances of employment law. And they may be focusing on the facts, but not on the record as it's developing. They may not be focused on maintaining privilege, which we'll talk about later. They may not remember they're dealing with an employee and not a criminal defendant. As we in the in-house community know, soft skills really, really matter. And I want to belabor the point that investigations are scary for employees, especially those who aren't in them often. So you want to make sure whoever you bring in as your independent counsel is going to be a good match for your issue and your company culture. And sometimes that means that you don't go with a brand firm, right? There are marquee firms that have excellent investigations practices, but your mileage may vary because, again, you're hiring the firm, but it's the person you're bringing in. And you're going to be responsible for the person that you bring in. And it's also, it's hard to know with an unknown quantity whether their focus is going to be on the areas that are important to you. So, I have had experience in my prior practice where I need to focus on a tree, but the forest looks so alluring to my investigator, and it can be a real challenge to say, I agree that deciduous trees are super interesting, but I really need you to focus over here on this little sapling, that is budding in real time. And of course, when you have an independent investigator, if the focus is off, it can be harder to course correct because it depends on the personality of the person you're working with, right? You want the investigation to be independent, but that doesn't mean that it can't be somewhat collaborative and that you can't provide guidance, not on what to say or how to develop the record or not making people available or restricting access. That's not what I mean. But making sure that the person who is coming in understands the environment and that they're landing in. You might find yourself, if you are suspecting that the investigation is going off the rails or going to yield a result or a product that isn't helpful for your corporate records, that you conduct a simultaneous investigation just to understand what people are saying and how the record is developing. But this is really tricky. I mean, Connie, you've been independent counsel. How do you recommend threading this needle? I mean, have you seen in-house counsel particularly successful in doing this?
Well, I think that, I've done my own independent investigations, sometimes mainly for governmental entities, actually, where I've done a report that's become public. And really hasn't had a challenge with it because I was independent and I know obviously employment law and things like that. And it is an important role, but the challenge is that in situations where I've been the outside counsel and independent counsels brought in, if they don't understand their mission and they don't follow what are the appropriate rules for handling witnesses, it can be a disaster. I mean, you can see claims brought by claimants where outside counsel or independent counsel have promised to them that their information is confidential, or they're representing that they're independent counsel when they're not truly independent counsel. And I do think it's important for you to lay out ground rules for the independent counsel to say, this is the product that we want. this is how we want you to handle the witnesses. Agree to whether there's going to be a report and what's going to be included in it, and who's going to get to review it, and how it's going to be distributed. When it comes to the facts, we'll give you access to the folks. We will, allow you to interview whoever you want to and ask them whatever questions you want to, but we're going to control the format. And if you're uncomfortable with that, we'll go with other counsel, because you don't want your independent counsel to become renegade counsel, looking at all those pretty other trees and going on this $1 million quest, and not really getting to the core issues that are important to you as a company.
And that goes back to, what I was talking about with setting up the investigative plan, is that one of the things you need to think about is, how can I conduct a comprehensive and defensible investigation while disrupting the workplace and our employees as little as possible, right? And so what you want to do is you want to be thoughtful about, you want to make sure you're interviewing enough people to really have, the right understanding of what's going on, and that you're not failing to interview any key witnesses. But at the same time, if there's an interview that's not necessary, you might just be inflaming the workplace by doing, more investigations that are necessary. You might be sharing information with future decision makers who don't need it, right? And it's only going to take a defense away from you later. And the problem with using independent counsel is that if you don't pick somebody who has the company's best interests at heart, and by the company, I mean no actual individuals at the company, not the current leadership, but the company itself. You want to make sure that you are using somebody you are confident is not going to go buck wild just so they can bill, right? And so it's really important to lean on those people that you trust, that you've worked with in the past in a way, or them reputationally in a way that that they are going to do the right investigation and not just an overly comprehensive investigation for the sake of itself.
I don't have this. Oh, go ahead, Andrew.
No, please.
I was going to say, I don't have it on the slide, but I would be remiss if I did not say that cost is a factor in selecting independent counsel. It is, full stop. Andrew.
And I think one thing to remember is hiring independent counsel is going to ratchet up the temperature of any investigation. And sometimes you hire independent counsel because you want to ratchet up the temperature, right? If you're a public-facing company that has a public-facing problem, you want the world to know that you hired independent counsel. But if you've got a relatively minor issue, and especially if you're in a company like mine, which is sort of a mid-sized company where pretty much every manager in the company knows the law department, and we deal with these folks every day. If my managers were to see a lawyer that's not me coming in the door asking these questions, they are going to assume that the sky is falling. And sometimes that's a good thing, and oftentimes that's not a good thing. So I think you really need to sort of gauge what exactly are you trying to accomplish, how much, as Amanda said, how much firepower is really necessary here, and then act accordingly.
Hey, to the fellow panelists, we have a couple questions in the chat that I don't know if we want to take up at this stage. The first is, well, actually 3 now. The first is, it seems that effective management of investigations depends heavily on 1, issue awareness, and 2, process awareness within the organization. Is a written investigations policy necessary or advisable? Let's take that one first, because I think that's unrelated to the others. I think a written investigations policy can be good, but it needs to give you the flexibility to depart from it, and to make judgment calls about what a comprehensive investigation is. I like having some guidance just for the people that are going to be conducting investigations that sounds a lot like what we've been saying here today. In other words, that investigations policy can say things like, talk with the following stakeholders about whether or not a report is appropriate, right? There's a lot of ways you can lay out and just make sure that the investigations policy is really more of a roadmap towards thoughtful design of an investigation rather than a prescriptive policy that tells you do X, Y, and Z. I mean, Connie, what do you think about that?
I was answering another question, actually.
Okay, do it.
No, I was just sending out a response to someone who had asked me a question directly. So, I actually wanted to I'm sorry, I accidentally captured part of, let me just skip for a second. I got a little problem here.
Sure.
I
We
think
So I can address the question that somebody asked about the chicken or the egg problem. How do you know when independent counsel is necessary at such an early stage? No real great answer to this, but I think there's a couple of things to sort of keep in mind and to think about. One is who is being accused and what are they being accused of? So higher up in the organization you go, more likely you're going to want to have independent counsel. And then think about what are you as an organization? If you're a nonprofit that depends on donations as your sole source of income to do the good in the world, and you're being accused of embezzling people's money or misusing it, probably want to get independent counsel, because even if it's a complete bogus charge, your entire business is based on the public trust. If you've got something that, if it gets out, even if it was true, is not going to be existentially threatening to your business, then you're far less likely to need independent counsel. So hopefully you'll be able to gauge that level of detail, even at the earliest stage. But I would sort of follow that as a guideline.
So let's go to the next slide, and it gives, I think, an example of a situation where independent counsel would have been advisable. We got poor Mr. Nguyen. He was a subject of a lot of allegations of prior sexual harassment in 2018, including an experience with a manicurist that resulted in a $7.5 million confidential settlement. He claimed the allegations were preposterous. The board hired O'Melveny to do an independent investigation, but then the Nguyen management stepped in, fired O'Melveny, and then hired Gibson Dunn, who was their long-term outside counsel, to conduct the investigation. This resulted in a shareholder derivative suit, or what is one of the allegations in the shareholder derivative suit, making allegations that the organization had turned a blind eye in the past to his sexually harassing behavior, and then were attempting to cover it up by hiring outside counsel who was not independent from the company. So that's a good example of a time when independent counsel would be advisable. Let's move on to the next topic. I know we had a lot of great questions on this, but we have to be mindful of the time. And so let's turn now to the issue of the preservation of attorney-client privilege. Andrew, and there we go.
Thanks, Connie. So as I was preparing for this last night, it sort of dawned on me that most of the time programs that cover attorney-client privilege are themselves an hour and a half to 2 hours long. And you could probably spend an hour and a half to 2 hours on just unpacking everything that I have to say. So unfortunately, this is going to have to be a little bit truncated, because also I don't think anybody wants to listen to me lecture about attorney-client privilege. So, but I do think it does, in order to sort of better understand how this relates to investigation, I think you do have to sort of take a step back and really think about what is attorney-client privilege. And so, for all of you who don't have this stuff memorized, attorney-client privilege is a confidential communication between a lawyer and a client for the purposes of giving legal advice. And to unpack that a little bit, and I think unpacking that becomes important because each one of these elements, I think our slide deck just went away, but I'll just talk. Each one of these elements is implicated in an investigation. And so looking at the first one, what is a confidential communication and why is that important in investigations? Well, very first thing is the communication. First of all, it has to be a communication. So facts, underlying facts, even underlying facts of an investigation, and even underlying facts that you really don't like are not themselves privileged. It's the communication about facts for the purposes of obtaining legal advice that can be privileged. The other element is it has to be confidential. And so if you are having what would otherwise be attorney-client privilege around people who are not attorneys or clients, and we'll get into sort of what that exactly means, you're going to waive that privilege, and that's going to open you up into an entire world of hurt. And then just one thing to sort of note, the adverse party is almost never going to be subject to the attorney-client privilege. So, you can debate whether speaking to an employee who has brought a complaint is a privileged communication or a waived privileged communication, but either way, it's not good to assume that is going to be protected. That raises sort of the second element of the communication has to be between a client and an attorney. And the subject of who in a corporation in the client can itself be probably an entire class in law school. And we could talk about the 1981 Upjohn ruling and what that means and what Upjohn warnings are. And, you know, we could go on and on and on about this. But I'll give you sort of the very, very high level of this. Who is a client for a corporation? Well, unfortunately for all of us, it actually depends on state law. And while under federal law, that definition has been expanded significantly deeper than what used to be known as the control test. I'd be remiss if I wasn't highlighting that when you're considering these things, you do need to think about what state are you in and what law is going to apply. So the breadth of corporate attorney-client communications in places like Illinois that actually don't recognize Upjohn and follow the control test is radically different than if you're in the Eastern District of Virginia. But rather than talk about sort of who is the client, I'll sort of tell you who aren't the client. Third parties are not going to be the client. If you are interviewing somebody and their lawyer is present, you're probably not going to have an attorney-client communication. And I think what's important to know is that attorney-client communications do not cover discussions between non-lawyers, even when those non-lawyers are talking about the investigation. The only time that may apply is if those non-lawyers are talking at the behest of a lawyer. So if I'm talking to the CEO about an investigation and giving legal advice, that could be an attorney-client communication. If my CEO goes and talks to the COO about the investigation, that is probably not going to be an attorney-client communication. And then the final element is for the purposes of giving and receiving legal advice. And where people mostly get themselves in trouble here is the difference between legal advice and business advice. And you could do an entire CLE on the difference, but I'll give you one way to measure this. If the advice you're given could be given by somebody who's not a lawyer, then chances are it's not going to be for the purposes of giving or receiving legal advice. And for us employment lawyers, that encompasses a lot of things. So for example, the question of would it be lawful to terminate somebody is a request for legal advice. If somebody asks you, this guy screwed up really bad, should I fire him? Most courts are going to say, that's business advice. That is standard HR, day-to-day HR decision-making. Just because you ask a lawyer that doesn't make it privileged. So another quick word on attorney work product, because it's a separate and complicated doctrine, but it comes into investigations in a very important way. Things like attorney notes, what you're writing down during an interview, that's not a privileged communication. It's not a communication with anybody. So the only way that is going to be protected is to show that it's work product. And luckily, you normally can show it's work product, because work product doesn't require a communication. But what it does require is that the document and the material being generated is being generated in anticipation of litigation. And that's a difficult concept because lawyers, we think everything is in anticipation of litigation, right? Most of what we're here to do is to either prevent getting sued or deal with it when we are getting sued. I think the best test that you can apply here is, would this document have been produced if there was no concern about litigation? And so that automatically throws out things like audit reports. You know, if you've got to do an audit every single year, that's never going to be work product. It gets a lot more complicated when you start talking about regulatory compliance. And I'm not an OSHA lawyer, so I will sort of step outside my comfort zone. But certain things that happen under OSHA have to be investigated. They have to be investigated whether you think you're going to get sued or penalized or not. And so does that become a work product doctrine? I don't know, but it certainly raises the potential that it's not. So I would say apply that test. Would I produce this document if there wasn't the specter of litigation? And the closer you are to litigation, the better. But one thing to sort of think about is, if you're going to assert work product, that may in fact trigger a preservation obligation. As you can imagine, it's very hard to go in front of a court and say, this document's work product. But at the same time, when the other side is saying, you destroyed all my evidence, you can say, well, we didn't anticipate litigation. They're going to turn around and say, well, then why did you label your report work product? I'll give you sort of what I think are the two best pieces of advice I can give you on the attorney-client privilege. And the best advice is, don't rely on attorney-client privilege. It is there as a stopgap measure to protect things from happening. But let's be honest, most of what we do is not privileged and it's not work product. The fact that your name appears on an email doesn't make it privileged. The fact that you wrote something doesn't make it privileged. One other consideration is, it's hard to know what law is going to apply when you actually have to defend this thing. You know, if you're sitting in Chicago and you're thinking about Upjohn, well, you're going to be in a lot of trouble if you find yourself in state court where the state courts still apply the control test. And you have no way of knowing in what forum you're going to get sued. Another thing, and you know, we're recording this, so I probably shouldn't say this, but courts screw this stuff up all the time. They don't know nearly as much about attorney-client privilege as a lot of these judges think they do. And it gets even worse when you're talking about a judge of one jurisdiction trying to interpret the way privilege is interpreted in another jurisdiction. And so, you know, you may be entirely right about attorney-client privilege, and I think we've all been there where we have claimed something is privileged, we were dead right, and the judge got it dead wrong, and you were forced to produce it. And there's nothing you can do about it. And then, you know, people waive inadvertently, right? Privilege is an easy thing to waive. It's mostly waived by people that aren't you. And so while you may be the best at protecting privilege, all of those people that you give privilege advice to, they don't sit around and they don't attend events like this to hear me drone on and on about this. So what does that mean? I sort of am old school in the use the phone as much as possible. Be very careful what you put in writing. And then I'll give you sort of the second best piece of advice. Remember, there's a big difference between what is privileged and what you can convince a judge is privileged. And so be very clear when you're sort of working through these issues. Make sure that you're labeling documents, but make sure you're not labeling all of your documents. If you label everything attorney-client privilege, you're basically saying nothing is attorney-client privileged.
Right.
So, you know,
let's
what we tried to do here is to, sorry, go ahead, Connie.
No, I'm mindful of time because we only have a half an hour left. And I just wanted to give a quick example. I inadvertently shared most of my notes about this slide about the Washington football team. And so I think you know what I'm going to say. But I think it's a really good example of what Andrew was talking about, which is we don't, you know, nobody really understands the attorney-client privilege and the scope. And you don't know what law is going to apply. So maybe the better way to think of things is, what don't I want to be privileged? Because as we mentioned earlier, if you're conducting this big investigation in order to figure out what happened factually and to make factual determinations, you may want to be able to present it more widely. You may use it in litigation as a defense. And so maybe more of the focus would be on, okay, that we know this is not a privileged document, so we're going to prepare it very carefully, keep it to the facts, not use mental impressions and attorney advice in it. And then on the other documents, you know, we don't know, but do we really care? That's a second category. And the third category is these have to be privileged. This is when Andrew is talking with Tamara about reporting in on an investigation, and they're going through all the different permutations, the defenses, the claims, et cetera. You don't want that privilege. So I think it's more important to think of it in those categories, because I put attorney-client privilege in the same bucket as restrictive covenants. You can't guarantee what way a judge is going to rule at all. So in terms of the Washington football team, I'm not going to spend very much time on it because it's more of an interesting sideshow that I've been watching in the press and then reading the docket on. I think the big issue that on the privilege, what was interesting to me is that, you know, Beth Wilkinson was retained by the football team with the approval of the NFL. 15 women came forward alleging prior sexual abuse and sexual harassment. And NFL said, okay, she can investigate this for you by the team. And so she was reporting into the team, and then 25 more women came forward with allegations that were similar to prior ones, but also specific allegations as to Dan Snyder, the owner of the team. So they took over the investigation, and the commentators were saying, well, what about the attorney-client privilege? And I had the same reaction. What attorney-client privilege? She's doing a factual investigation. I don't think she was styled as independent counsel, but I think that was the intention. So probably very little of what she's doing is privilege. And the big brouhaha in the Eastern District of Virginia was about a $1.9 million settlement that Dan Snyder entered into 10 years ago. And I think the moral of that story is if you want something to remain confidential, don't file a lawsuit in federal court trying to keep it confidential, because all it did was highlight it and everybody figured out what happened as a consequence of the filed lawsuit and then the months of proceedings about sealing. And a side note here is last week, Judge Ivan Davis unsealed a lot of the records. So if you want to look into this stuff, it'll probably be available in another week on the docket. The next slide, we were talking, turning back to you, Andrew, about some recommendations for attorney-client privilege. I know you talked about a couple of those. I didn't know if you got a chance to address those if we go into the next slide, Sasha. Thank you.
Yeah, and Connie, you very helpfully, there are so many things you need to consider here. I think that Connie, you very helpfully gave us a good list of things. In terms of carefully training the investigator, this sort of dovetails into who's going to do the investigation. Look, attorneys don't understand the attorney-client privilege. So the idea that non-attorneys are going to understand the attorney-client privilege is absolutely a pipe dream. I think we would all agree that generally speaking, having an attorney do the investigation is the best course of action. But it's not always possible, and especially in large companies that have entire investigative staff. But what is absolutely critical is if you're not going to have an attorney do the investigation, you need to have an attorney supervise that investigation. You need to have that attorney be the beginning and the end of all of the work product that comes out of that. So you need to have it needs to be the attorney that tells the HR official to go talk to the witnesses. It needs to be the attorney to whom those HR people come back and provide that documentation. And it needs to be an attorney on every step of the way, because I think as you all know, something doesn't become privileged just because you hand it to an attorney. So if your HR department or your internal audit department conducts an investigation, finds something that is absolutely terrible, and then hands that report to an attorney hoping that they're going to never have to share that report outside, you're going to lose that battle every single time. So courts and plaintiffs' counsel are very aware of that there is a timing element to maintaining the privilege. One other giant issue for in-house counsel is a lot of us do a lot of work that is, quote, not wearing our attorney's hats. You know, all of us have non-attorney responsibilities, and it's very, very difficult for, especially if you're in a medium-sized organization where resources just don't allow you to be a lawyer 100% of your time, to make sure you're wearing that attorney hat. One way to sort of sidestep this problem entirely is to hire independent counsel. If you are that worried about this investigation being privileged, I suggest you hire independent counsel, because, you know, Connie doesn't have to worry about whether or not she's giving legal advice or business advice, because we only go to Connie when we want legal advice. And it's very easy for a court to wrap their head around that. It's a lot harder for a court to wrap their head around the fact that in this organization, you know, this person is the attorney and the corporate risk officer, or the corporate privacy officer, or the diversity officer, or whatever other hat you wear as an attorney. And then on the issue of notes and dual notes, I think one thing to sort of keep in mind is notes are not generally going to be attorney-client privilege. So you're going to have to rely on the work product doctrine, which means you're going to have to add something more than just a recitation of the facts. And so I think what Connie is suggesting here, and Connie, please, you know, chime in, is that sometimes it makes a lot of sense to have one person be responsible for taking a record of the facts and another person responsible for giving the, quote, legal advice or to analyzing those facts. And the other advantage to that is it allows you, if it becomes necessary, to have that note taker actually testify in court or to talk to the government without having to worry about waiving the privilege. If all they're doing is recording the facts, then they won't be revealing any of their own mental impressions, and you don't run into that sort of morass. And then the final recommendation, and I think this sort of encompasses a couple of these, is be very careful who you're sharing what information with. A lot of organizations, you know, like to, especially if you're in sort of a matrix type organization, you end up with very large leadership teams that sort of get involved in just about every level of decision making. But be very careful about what level of information you're giving. If you've got a potential problem in business unit A, does the VP of business unit B really need to be involved in the investigation or to get that final report? Probably not, because the wider you spread that net, the more likely it is to not be found privileged or work product, and the more likely you are to have sort of an inadvertent disclosure.
Andrew, another thing I like to do is just, if I think I'm going to need to do a privileged investigation at the very beginning, I just evidence my intent. I send an email that says, you know, to the people that I'm going to need to assist me with the investigation, and I say, The legal department is conducting an investigation concerning X, Y, and Z allegations. The purpose of this investigation is to collect information for the legal department to provide legal advice to the company. We need to discuss next steps before you take any action on this matter. Do not take any action or have any additional contact with the reporter or anyone else that's discussing with me first. As this is a privileged and confidential investigation, all written documents must be kept confidential, and all emails and written materials should be labeled attorney-client privileged. Emails concerning the investigation should be distributed only to essential employees at my direction, and I should be included on all emails. Do not forward my emails to anyone else, and if you need data from anyone, please coordinate with me before requesting it. Please do not prepare any report, summary, or similar document, either formal or informal, without first seeking my approval. And then you can kind of talk about next steps, but that's a great way to just evidence intent and lay the groundwork to make sure that it's clear that you're directing the investigation for the purpose of providing legal advice.
Thank you, Virginia.
That's fantastic.
Why don't we turn now to reporting up to the board, and Amanda's going to lead us in that discussion.
Sure, thanks. So starting at the top with what triggers the obligation, this is an opportunity for me to use my very, very favorite attorney answer, which is it depends. It depends on your company's policies, practices, and procedures. Your board's bylaws might address it. It could be a decision that's born of your corporate risk tolerance. Some of the easier examples that come to mind are, again, a claim that involves a high-level executive who could be fired if the allegations are true. Allegations of fraud, allegations that could have impact to your financial statements, especially if you're publicly traded, if you're a government contractor, if there is potential for debarment. Again, if litigation or investigation is likely, if it could hit the media or tank your stock value or damage your reputation such that you will be unable to recover, these are the kinds of triggers that are likely to involve the board. So what do you share with boards and committees? Well, it depends, right? So a rule of thumb that I use is, where possible, not to use names in reports unless it's absolutely unnecessary. And this is particularly important where the result is that the person is exonerated. Why have the additional record floating around with the person's name in it? And why bring that person to the attention of the board if, again, the facts ultimately lay out in their favor? This is a really delicate line to walk, however, because it's very uncomfortable as in-house counsel and even outside counsel to say no when someone asks you a direct question. So I recognize that that's a very delicate area. We were talking in the earlier section about limiting knowledge to persons with a legitimate need to know. That's how you can control confidentiality and privilege. But as with any large group, it's always going to be challenging. So keeping that group as small as possible on a need-to-know basis is essential for your board. Maybe it doesn't need to involve your whole board. Maybe it involves only your audit committee. Controlling statements by the board, good luck, right? In a perfect world, you say, hey, you shouldn't talk about this, and they don't. But we don't always live in a perfect world. So one way around that might be to encourage your board to appoint a spokesperson so that the company is speaking with one voice. And for you publicly traded companies, this might be a good opportunity to do a refresh on that Reg FD training, or gently suggest to your independent counsel that the board would benefit from an overview on what might or might not cross a line and result in additional disclosures. But what if the board retains its own counsel? Well, in my experience practicing, it's been rare that the GC and the board don't agree whether an independent counsel is needed. Now, I suppose if the GC is the target, that might be an area for disagreement, but I myself haven't seen it. Connie, in your experience, is this an area where you see a lot of disagreement?
I don't think it's necessarily a matter of disagreement. There's certainly situations where the board or committee of the board has to step in if the general counsel, obviously the general counsel reports into the CEO, and if the CEO is the target of the allegations, very often the board will, or committee of the board will take over the investigation, retain counsel, consult with the general counsel, but kind of take it out of their hands just because, someone above or at their level has been accused of misconduct. Or, and as I had in a situation recently where I was retained by a board of a nonprofit, the general counsel was implicated as a witness in the investigation. So actually, I see this a lot in the nonprofit side, and actually I've been independent counsel for a number of nonprofits doing investigations. And in that situation, it makes a lot of sense because otherwise the general counsel is going to be inherently in a difficult position, if nothing else.
Mm-hmm. I suppose it also matters whether the board or the committee that's appointing the independent counsel itself has counsel in its membership. Have you had an opportunity to report to a committee with no lawyers on it?
Absolutely.
How have you walked them through what they're about to open up?
So it's can be challenging. For instance, for a lot of the nonprofits I've represented, they don't have legal counsel. Sometimes they do have legal counsel. It's not necessarily helpful, quite frankly, because they do a different kind of law. But you have to almost kind of make certain that they do the right thing in terms of confidentiality, non-disclosure on your own or in coordination with the general counsel as part of your role as counsel retained by the board. Kind of steering them in the right direction to make certain that they do the right thing. And they're very reliant on you as outside counsel to give them wise guidance with respect to the matter. In some instances, you'll have an outside investigator, outside independent investigator, and then they'll have outside counsel providing advice with respect to the investigation, which is the best situation because you've got an independent attorney who's acting as counsel for the organization, and then you've got the independent counsel who's assessing the factual situation. And on the next slide, we talk about a situation where the board wasn't very good about maintaining confidentiality or keeping their mouth shut. And there was a very public investigation and allegations and investigation against the Humane Society and its long-term CEO. And I quote there the statements of one of the board members. And she said, "Which red-blooded male hasn't sexually harassed somebody? Women should be able to take care of themselves." Well, she was excused from the board the next day, but the damage is done once that comment is made. And there was a tension there because this was very public. It was reported in the media, and the organization had initially supported the CEO, had declined to remove him from the position. Then additional facts came out, and they had an independent investigation. So there was a lack of control, control over communications in that situation. Unfortunately, I should move forward in the topics and go to the next one, which is limitations on communications and self-help discovery. And I'll take the lead on this, as many of you know, because I recognize a lot of the members of our audience. I've spoken about this topic a number of times, and I know it continues to bedevil in-house counsel. In fact, I said to the other panelists, well, maybe we could cut this down. They're like, no, we've got to talk about that because it's such a difficult issue for in-house counsel. And, essentially, if I can quote Amanda as to, the first question, does protected activity by an employee include self-help discovery or informal discovery efforts by the complainant and witnesses? Maybe. It depends. It's a multi-factor analysis the courts have developed over the last 2 decades, where they're looking at, how did the employees secure the information? What is the information? Did they use illicit means to get it? And what was the purpose of the removal of the documents? Was it, their own personnel records in order to support their case? Or on the other side, was it information designed to conceal their own involvement potentially in fraudulent activity? Or even as a case I had a number of years ago, stealing the information in order to design a competing product to sell to a competitor. So you've got to look at all these different factors. And again, I'll put this in the bucket with restrictive covenants and attorney-client privilege. I've had many cases where this becomes an issue in the litigation. And sometimes the judges are, enraged, eye-popping. They cannot believe that the employee did this, and they'll sanction them with dismissal of their case or otherwise, impose sanctions. In other cases, they're just like, they don't seem to really care about it as much. So you really have to gauge, in litigation at least, you have to gauge the judge and gauge the situation. At this point, I don't think many judges are going to get ruffled up about an employee taking his own personnel records or information relating to their performance. But when you start getting into other employees' personnel records or trade secreted information of the company, that's going to be a bigger issue. Where you run into major problems is if you're trying to control the removal and disclosure of information where there's a parallel government investigation. The SEC has taken the position that basically employees have an unfettered right to provide information in support of any claim of fraud in their investigations. State rules and federal rules are inconsistent with that. But essentially, if they're providing the information solely to government officials, they may be protected. That can even go overboard, and it doesn't excuse all the wholesale theft of documents relating to company malfeasance. But it's a really tough issue. And if you're in-house counsel and you have a situation where you suspect or you've gathered some evidence that an employee has removed confidential and trade secreted information of the company, you need to do a careful investigation of the situation, look at the existing company policies and agreements, and how the situation has been treated for other breaches by other employees. And importantly, has the company been consistently acting to protect its trade secrets and confidential information? You don't want this to be a situation where other employees have been allowed to leave the company with no monitor of what they're taking, and all of a sudden you have a whistleblower and you're terminating him or her because they've removed some documents that they consider to be critical to their case. It's a really, really difficult issue. And in the materials, I cite to the JDS Uniface case. Andrew and I really loved this case. We were talking about it. And in that case, this is a case by Judge Ellis, it presents kind of the older view, which is basically, if you have a case before Judge Ellis, raise self-help discovery. Judge Davis, most of the judges in the Eastern District of Virginia, they can be very, very responsive to it. And I've had 3 separate cases dismissed as a sanction because of spoliation or self-help activity by an employee. So quote this case, but the result might not be the same anymore, and you're not going to be able to predict, except maybe with Judge Ellis, that you would get the same result. I also gave an example of a long-running case, if you go to the next slide, that I handled for what was first Impact Science and Technology, and then it was EDO, and then ITT. It made its way through the Federal District Court in Maryland and then up to the Fourth Circuit. But this was a situation I alluded to earlier where we had a principal engineer who was making allegations about the heat threshold for modules that were used in counter IED devices used by the federal government in Afghanistan. And he himself had directed the tests. He's the one who set the temperature threshold. And then when the government questioned this, he then tried to make a fraud claim. The government investigated, found that there was no problem with what the company had done. But meanwhile, he was taking the designs for the modules, the CAD files, and removed them himself, both through various means, including just printing them out and emailing them to himself. And then when he left, after he was terminated, he had a coworker continue for a period of 6 months to not only send him design files that he needed for competing designs that he was creating, but sitting in their secure facility, doing design work for the former employee and being paid for it. We started a counterclaim and won. It was a very egregious situation that was actually hard fought because we had to get experts in, and we actually had the company that he sold the designs to agree that they were stolen from IST, EDO, ITT. But it proves a couple of different things. First of all, it's really expensive to go down this road. And number two, if you're going to assert a counterclaim based on even this egregious conduct, you got to think carefully about it. We were slapped with anti-SLAPP claims. We were hit with retaliation claims based on our very legitimate counterclaim. And you have to proceed with caution. Number one, when you're terminating somebody for removing confidential files, and then deciding whether to assert a counterclaim based on that action. Now let's move on to the next topic. And I think Virginia, you were going to take the lead again on this one. And this is kind of a wrap up topic for us. You know, we've talked about a lot of different issues, and, you know, how do we do effective investigations, but also reduce the risk of whistleblower claims, Virginia?
Yeah, I mean, I think that, you know, I don't want to dwell on this too much because I know that we're low on time, but, you know, there can be a lot of different reasons that somebody brings forward a concern. They can be raising it in good faith. They can be raising something in good faith, but based on a lack of understanding. They can be disgruntled, both either because they're poor performers or because they have some personal beef with some other person in the company. Or they could just be wanting a payday, right? And so there are a lot of different reasons that somebody could be coming forward as a reporter in a case. And I think it's really important to understand those motivations from the beginning to the best extent that you can as the facts develop, and that they should influence, you know, how you handle and communicate with that complainant. Kasha, can we move to the next slide? You know, I think it's really important, you know, even investigating the whistleblower has to be done carefully, right? Because you do want to avoid anything that appears retaliatory. I usually engage in a lot of self-help. You know, as the lead labor employment counsel for my company, I have access to personnel records, I have access to the hotline, I have access to a lot of things. And I used to counsel people, you know, in the same role when I was in private practice. And I think it's important to understand in any, you know, hotline, whether it's, you know, somebody's a potential whistleblower or not, you know, who they are and what their motivation is, and it can go to credibility, you know, when you're trying to come down, if you have a he said she said kind of situation, you know, you have to assess the credibility of all these different circumstances. So I think, you know, just understanding, is this somebody who has raised concerns in the past? Were those concerns, you know, apparently driven by good faith, or is this somebody who seems to be a malingerer? You know, what does this person's, you know, performance record look like? You know, are they somebody who's been a good performer? Are they maybe a more recent hire that doesn't understand a lot about how the company does things, and maybe confused because things are different than what they're used to, and therefore misreading, you know, what they're seeing. And I think it's important to understand all of that. And, you know, as in-house counsel, like, this is the value that we add, right? I mean, there are a lot of things that we add, but, you know, outside counsel is never going to know your company as well as you are, and they're never going to know the players as well as you are. So it's really important to share as much context and history with your outside counsel as you can when you're dealing with a situation like this, so that they got the benefit of all of the historical information around what might be driving, you know, somebody who raises a report in this kind of situation. I think it's really important to think about the motives when you're deciding who's going to communicate with the reporter. I mean, you've got, if somebody feels like they're in the middle of a department that is just rife with corruption and everybody's doing something that's wrong, you want to try to find somebody who's independent to reach out to them. You know, somebody in the company that might be seen as not having an agenda and being removed from, you know, the drama of the, you know, the department that's potentially the issue. You know, this is where having an independent compliance function is great. You know, when you've got compliance investigators that aren't affiliated, you know, with any particular group or department. Sometimes I've recommended HR from like a different department step in, somebody who's, you know, maybe usually supports a different group, but they've got a lot of experience. You might want to bring them over so that there's no feeling that it's somebody with relationships. And figuring out who that person is that's best going to communicate with your reporter. If you've got an investigator who's handled a prior investigation involving this person and the reporter didn't like the outcome of that investigation, you might want to involve somebody different for the communication so they feel like they're getting, you know, an independent look at things. I think also when you're communicating about the outcome of an investigation, you need to think about the seriousness of the allegations and decide, do you need somebody who is of sufficient stature in the company to communicate with the reporter so that the reporter knows that this was handled at a high level and there was insight into all of the concerns and it wasn't just handled at some lower level and minimized in some way. So even just who the person is that communicates with the reporter about the conclusion of investigation. I think, you know, understanding the motives will determine how much information you share. You know, if somebody is a confused do-gooder, actually sitting down with them and walking them through a process or explaining all the detail around why they don't really understand what happened can be your best move, and it can prevent them from becoming, you know, a relator or a whistleblower to some sort of government agency. You know, but obviously that's absolutely the wrong play if it's somebody who's an opportunist or just out for a cash grab, because all you're doing is giving them free discovery early on into like what you're going to try to argue in court. So trying to figure out those motives can be really important, and figuring out how that influences your communications is important. I already talked earlier, so I won't belabor it, about, you know, figuring out how to do an investigation that's not perceived as retaliatory. And I think that goes back again to balancing, how do you do a comprehensive investigation without just going to people that aren't necessary for a comprehensive investigation. You know, don't involve management if you don't need to. Don't involve, you know, coworkers if you don't need to. Who are the real witnesses? Who are the people that really have information that you need to talk to? Don't just spread knowledge of this investigation all over the company by involving everyone and their mother, right? You know, you need to be judicious about who you're going to involve. And sometimes you're going to learn things about the reporter in the course of an investigation that you can't avoid doing something with. And then you need to think about that, right? And that can be in the case of misconduct or a false complaint, but it can also just be you just happened upon some other piece of information, you know, about the reporter that you can't ignore. I had a client once who found racist emails from a reporter in the course of an investigation where they thought they were just looking to see, you know, what concerns have been raised. And in the course of that, they found racist emails, and they couldn't just ignore that. I mean, you can't have knowledge and not discipline someone in that situation. And so in that case, the in-house counsel actually sat down with the reporter and said, look, like, you know, we're not retaliating against you, but we can't ignore this. And we have to issue discipline to you, but we're going to give you a chance to rehabilitate. And really, we mean it. Like, and they had to credibly have that conversation with the reporter. And, you know, to my knowledge, nothing bad ever happened with that reporter. So, I mean, you need to not ignore things that are, you know, defensible things that you need to issue discipline to a reporter or a participant on. But you really do need to be wise. I mean, what I always think about, and Connie, I'd be interested in your thoughts, but I always try to think about, if I have to take an employment action with a reporter in a hotline, is this something that is defensible enough that I'm going to win summary judgment, right? Because with retaliation claims, the issue is that discrimination cases are actually much easier to get taken out before you go to trial than retaliation claims. So what you don't want to do is hand a claim to a reporter that gives them a cause of action that they're going to prevail on that they didn't previously have. And retaliation, the standard's just so much easier to move forward. And so I think it's really important to think, again, going back to Connie's earlier point about that litigation lens, are you going to be able to show that this is just so clear cut that the action had to occur, the adverse employment action? And then, as far as, managing the complainants of ongoing employment, I generally give an instruction to the managers or HR or whoever has need to know that I want to know if there's going to be any action taken against this person that affects their promotions, their pay, their employment status for at least the following year, and make sure that I'm just involved, in giving counsel about it to make sure, again, that the facts on which decisions are being made are defensible. Connie, I know we're running out of time. Do you want to talk at all about counterclaims or anything like that to bring us home on that?
Yeah, I talked a little bit about counterclaims when in discussing the Glenn case. Let me go up one topic to as kind of a final word to termination based on the complaint being false. It's obviously a very tough road to take. I include on the next slide the Day versus Staples case. It's an older Sarbanes-Oxley case from 2009, which is only 7 years after Sarbanes-Oxley was enacted. But it's a case where the investigation was handled really well. They met with the complainant. They provided information to the complainant. They did 3 different, I think, rounds of investigation based on his concerns. They, as Virginia recommended, thinking he was just innocently confused, sat down with him and explained to him why the rebate program that he was challenging was not a problem from a financial or security standpoint, and it actually benefited consumers. And he refused to get it. And he was, being adversarial with his supervisors and refusing to do basic functions. And they terminated him 2 days after they met with him, after they had repeatedly advised him, we've explained to you why this is not a problem. And, we don't know if you don't understand it or you're just refusing to accept it, but you can't do your job if you're refusing to do this function, which is one of your essential duties. Mm-hmm. And it is a great case. I cited a lot in my Sarbanes-Oxley whistleblower cases. It's a very thoughtful decision about the scope of Sarbanes-Oxley and the like. But, when I get to the end of the saga and then they terminate him 2 days later, I'm like, okay, finally, not that I want everybody to be terminated, but when you have someone like this who's being disruptive and refusing to intake information, and he'd only been working he was only like 24, 25 years old. He'd been working for the company 7 weeks before he started complaining. So I'll end with that and invite you to look at the Day versus Staples case. And then on the next slide, I identified some decisions that that I or others made reference to during the course of the presentation to give you the sites for those. What I'm also going to do is set up an information site for the attendees that has the slides, a paper that I've written on self-help discovery, which has a lot more granular detail than our discussions today, and some of the key decisions and some other materials I've written for the ABA on these topics. And so that you can have that as a resource without having a heavy data-rich email with a bunch of PDFs in it coming your way. But I wanted to thank everyone for attending and especially thank the panelists for participating. And I think, Amit, you have some parting words for us.
Correct. Yes. At this point, we must conclude today's roundtable. On behalf of our chapter, I'd like to extend a special thanks to our sponsor, Bertram LLP, and Connie Bertram, Andrew Sakalaris, Amanda Dupree, and Virginia Robinson for leading this discussion and providing this important insight. While we had hoped to have this event in person, we're thrilled that we were able to gather virtually, and we hope that you'll contact Connie if you have any additional questions that she can address. Thanks again for joining us.
Thank you, everybody.